Dear guests, my name is Roman. I work for the Center for Civil Liberties, and today I will be a moderator of this lecture. The idea to conduct a lecture on the IHL topic and deliver it to Ukrainian civil society originated from CCL activities in documenting war crimes committed by Russia and its proxies. And in this regard, our good partner, LPG, provided a great service to us and helped us to prepare this event today. To briefly present public international law policy group, it is almost impossible because this organization was founded in London in 1995, and currently the headquarters is in Washington, D.C., United States. Public International Law Policy Group is a global pro bono law firm specializing in peace negotiation, post-conflict constitution, and transitional justice. It is also a Nobel Prize nominee, Nobel Peace Prize nominee. And for us, it is an honor to have them today with us. Public International Law Policy Group advises its clients, which include governments, NGOs, civil society groups worldwide, various matters that are concentrated on peace building and public international law. And today we will hear a lecture titled Exploring International Humanitarian Law and its Application During the Russian War in Ukraine. Our speaker, Professor Dr. George Noone, will put a concrete norms of IHL, concrete norms of Geneva Convention into legal reasoning based on facts on the ground, based on facts on the front in Eastern and South Ukraine. Our webinar, our previous webinar is available in our YouTube channel, and the link will be in the chat. Please do write question into the chat, and we will discuss them whether during the event or after event at the Q&A session. You can type your question in Ukrainian or English. I will help to translate them to English. We are ready to start, and the floor is yours. Thank you.
Well, Roman, thank you so much, and thank you everyone for being here today. It is indeed a privilege to be here with you in such a historic time for your organization. I know everyone at PLPG was so thrilled for you and so excited for you, and all the Americans that I've talked to and all the internationals that I've talked to were so supportive of your efforts, and so that recognition is well deserved. So congratulations to all of you and the work that you do. Today we're going to talk about the law of armed conflict, also known as International Humanitarian Law, also known as the law of war. They all mean the same thing. So when you hear the different phrases, don't get confused, because it all means exactly the same thing. We're talking about the body of law that governs when there is an armed conflict. So Roman sent me a brief outline and some questions that he wanted me to get to, and I will do that. I also want to encourage you to ask questions at any time during the process. I know we'll have time at the end to also address questions, but during the conversation, it's always nice to raise your hand and say, okay, I don't understand what you just said, or what about this? And I'm more than happy to approach that. I purposely do not use PowerPoint slides because I want to have it more of a conversation and less of a lecture. But I do want to address some of the things that were sent to me and some of the questions that were sent to me in advance. So first, let's start with the history. How did we get here? The law of armed conflict really, truly is centuries old. You can find it on sources on every continent, every culture, every religion. The law of armed conflict has grown organically around the world. And as we trundle along in human history, unfortunately, in and out of conflict, we hopefully got better and better at trying to protect those who cannot protect themselves. And that's really ultimately what the law of armed conflict is about. to protect those who cannot protect themselves. So you can think about that quote, think about that line, and as we roll forward, who are we trying to protect that cannot protect themselves? So the law of armed conflict really had a major move in the middle of the 19th century. In the 1850s, there were two massive events. One of them, the Crimean War, and the other, a battle, a little known battle called the Battle of Solferino, that took place during the Italian Wars of Unification. And both of these events in the 1850s really helped bring a lot of attention to the wounded on the battlefield and to the brutalities of war. And prior to that, we get a lot of history being told by the winners. History is being told by the admirals and the generals, and his death was a glorious one. He died for the motherland. And when the reality of it is that battlefield environments and battlefield injuries and deaths are horrible and destructive and devastating. And so we really have a jumping off point in the 1850s. Shortly after that, the American Civil War begins, and we have a very famous law professor here in the United States who was an immigrant from Prussia. He was a Prussian Jew by the name of Francis Lieber, and he wrote the law of land warfare for the United States Army. And so we have these events put together, and we start rolling into the formation of the International Committee of the Red Cross, the first Geneva Convention, into Hague Conventions, and then more Geneva Conventions. The law of armed conflict is reactive, just like every other law. Very, very rarely do people in positions of power, people in government, very rarely are they able to look over the horizon and create laws before there are problems. Oftentimes, the laws are a reaction to a problem. So, for instance, World War I, massive cataclysmic event. The two biggest issues out of that, one, everyone knows, chemical warfare and the gassing of thousands in a single day. But the other one was also this massive amount of of prisoners of war. And so at the end of World War I, the international community got together and they outlawed the use of chemical weapons. And they also wrote the first Geneva Convention on Prisoners of War in 1929. Move forward to World War II, again, massive cataclysmic event. So rolling after World War II, you have the 1949 Geneva Conventions. And there are four of them. One deals with law of dealing with the sick and wounded on land. Two, sick, wounded, and shipwrecked at sea. Three, prisoners of war. And four, dealing with civilians, which was really a new point for us in international law, because it's the first time that we're addressing civilians specifically and really addressing those civilians with respect to occupation, what happened in World War II. It really, if you know your history, the four Geneva Conventions are almost a laundry list of what the Nazis and what the Japanese did in fighting in those wars. Of course, other law builds behind that, the 1948 Genocide Convention, the 1954 Cultural Property Convention, and so on and so forth. Fast forward into the 70s, and we have the 1977 additional protocols to the Geneva Conventions of 1949. So those protocols were added on in order to supplement what we already did in 1949. Additional Protocol 1 deals with international armed conflict. Additional Protocol 2 deals with what the law calls non-international armed conflict, what normal people would call internal armed conflict. And so those were designed to add to the 1949 Geneva Conventions. And those came about through the post-World War II era when you have decolonization and wars for liberation. So we knew we needed to shift some of the rules in order to adapt to what was going on the ground. So that's a brief history of the law of armed conflict and how we got here. Another question was asked about customs versus treaties. Treaties obviously are are negotiated and agreed upon by the parties, whereas customary international law is exactly what I spoke about earlier. It grows organically around the world. And customary international law becomes customary international law when, one, there's state practice, people are doing it, all the countries are following it, and two, there's a sense of legal obligation in order to follow it. So state practice and the sense of legal obligation gets us customary international law. The only way customary international law can be defeated is by states acting as persistent objectors, continually speaking out against the formation. So let me give you an example. You, of course, know in 2014, Russia illegally invaded your country and stole Crimea. Russia has then perpetrated this fraud where they say that Crimea is part of Russia. It's no longer part of Ukraine. So you have countries around the world, my country and other countries around the world, that on a regular basis in different forums will say, we reject the Russian claim of owning Crimea. And so we're acting as persistent objectors. So I know that sometimes doesn't feel satisfying. There's a lot in the law that doesn't feel satisfying, particularly international law. But the fact of the matter is, by countries continually speaking out against it, it does not let that customary international law take root, and it does not grow. So they cannot claim that Crimea is theirs. And Olga just corrected me. You're right. It's occupied territory. I see it as a violent crime. I will tell you this. I have a special place in my heart for Ukraine. I spent a better part of the late 90s training the Ukrainian military in Crimea, in Kharkiv, in Kyiv. My experiences, I was 30 years United States Navy and retired as a senior officer in the United States Navy. And my job was to train foreign militaries like yourselves. So I spent a lot of time there, and it's heartbreaking to see a country that I love being impacted this way. Okay, so that's some of the background. Now let's kind of pull back a little bit and talk about the law and how it impacts where we are. Every day, human rights impacts our lives. So think of human rights as an umbrella that we all live under. Now remember, human rights are your relationship to the government or your relationship to that authority that controls where you live. Okay, so human rights isn't me walking into a bar and punching Roman in the face just because I felt like it, or because I had too many drinks. That's just a crime. That's assault and battery, and I should be arrested for it. But the human rights are how you're treated by the people that control your territory. And so human rights, we live under this human rights umbrella. In a little box here is armed conflict. And that's when the law of armed conflict kicks in, when there is in fact an armed conflict. So we need to make a determination that there's an armed conflict. So human rights are what we would often refer to as lex generalis. It's generalized law that we all live under. Whereas the law of armed conflict is lex specialis, which is specialized law. And whenever there's specialized law, it trumps generalized law. So inside this law of armed conflict, that's where we're inside the armed conflict. That's where we're going to apply that law. So for us, the answer is simple. Is there an armed conflict? Yes. One state invaded another state. That's the easiest determination of armed conflict. The armed conflict analysis becomes much more difficult if you're talking about internal armed conflict, or what the law refers to as non-international armed conflict. That's when you have to go into an analysis of intensity and organization. What is the intensity? What's the number and duration and the intensity of the conflicts? What's the organization of the entities that are involved? Do they have the ability to train and recruit? Do they have the ability to issue military orders? So there's a lot of that analysis that goes on with respect to a non-international armed conflict. But what you're living in is an international armed conflict. And that makes the analysis much clearer and much cleaner and without any debate. The other thing that's interesting here from a legal point of view is when you're in an international armed conflict, you get the full Monty of the law of armed conflict. You get all of the law of armed conflict, all of the Hague Conventions, all of the Geneva Conventions, all of the customary international law. When you're actually in an internal armed conflict, a non-international armed conflict, you actually only have a very little amount of law. You only have common Article 3 of the 4 Geneva Conventions, and then additional Protocol 2, as well as customary international law. So you benefit by having all of the law of armed conflict. You have just pounds or kilos of law. Whereas when it's in a non-international armed conflict, we're only talking about ounces and grams of law. So that's one of the main stepping off points here. Is there an armed conflict? And what kind of armed conflict? That's the first part of the analysis that we have to undertake. And so we're fully here inside of this armed conflict. So what's next? What do we look at next? I'm sorry, go ahead, Olga, you had your hand up, please. Go ahead.
I'm sorry, can you hear me?
Yes.
Mr. Noone, thank you for your lecture or not lecture. I'm sorry, I'm usually rather active. You say when you have international armed conflict, but when you have international armed conflict ruled by treaties and laws, just in theory, then it will be treated by treaties and laws. But if you have or genocide by how to say definition of political nation as Ukrainians, political nation, yeah, not ethnic, or you have attempt of genocide, or you have act of aggression, then you need to think which law, and such law may be not existed at the moment, because as you mentioned, such law can be created in organic way. So let's create this law in organic way.
So Olga, it's a great question. And I would argue that everything you're talking about already exists. So the Genocide Convention in 1948 is very clear on what makes a genocide. Crimes against humanity, although there is not an existing international convention, it is accepted as customary international law, and it has been even more defined in the Rome Statute for the International Criminal Court. So even if we're not talking about, oh, this case will go to the International Criminal Court, the fact that the international community has agreed to these ideas of what makes crimes against humanity, that helps us. So whether we take that into an ad hoc tribunal, whether we take that into a special domestic tribunal, that helps us immensely. And then, of course, war crimes is what any violation of the law of armed conflict, a grave breach or a simple breach would still be a war crime if you're violating the law of armed conflict. So I kind of look at it as a triangle, as a hierarchical pyramid, war crimes as the foundation, crimes against humanity, and then genocide at the top. So it's really, if I can say this, and I don't want anything that I say to sound cavalier or unfeeling, but war crimes generally are what I would call one-offs. A soldier did a violation, right? Maybe killed a civilian, maybe raped somebody. That would be a war crime. When you start talking about many soldiers killing civilians or raping people, that's when you start moving up into crimes against humanity. So crimes against humanity, the key words there are widespread or systematic. So a soldier doing something bad on the side of the road, war crime. A whole battalion doing something in a particular village, crimes against humanity. And then, of course, genocide has that very specific element of specific intent to destroy in whole or in part, either because of ethnicity, religion, nationality, or race. So genocide is always going to be the hardest thing to prove because we must prove that the victims fit into one of those 4 categories. That will be the key to proving genocide. So if Russia is killing Ukrainians because they're trying to eliminate the nationality of Ukraine, then that would be the argument for genocide. If Russia is killing Ukrainians because of their political support for a particular candidate, well, that would be crimes against humanity, because politics, very specifically political groups, is not part of the Genocide Convention. That was part of the negotiations in 1948, and it wasn't going to be able to get the convention done if they included politics. And then, of course, any soldiers out there committing crimes in the armed conflict that will be war crimes. So we have to kind of look at the whole picture and take the facts as we find them, and then take the facts and analyze the law and determine what the crimes would be. So you bring up the issue of commanders' orders. War crimes, and I'll talk more about them in a minute, but it's a great question. Who's responsible? Well, first and foremost, the individual soldier is responsible for his actions. And using an orders defense, I was just following orders, does not fly. We did away with that at the Nuremberg tribunals. And so soldiers have a duty, every combatant has a duty not to follow an illegal order. And so if the order is on its face so obviously illegal, take those women down to the river and shoot them all. Clearly an illegal order. And soldiers must not follow that. In the US military, the way that we train that, in the way that we train that around the world, is that if you receive an illegal order, you have an obligation to either go outside of your chain of command or to go up the chain of command, go around the person giving you that order, because you do not have an obligation to follow it. So the first point would be to seek clarification of that order. And the second point, if receiving the same illegal order, would be to go up or out of the chain of command. But at no time will you be allowed to say, I was just following orders, when it was a patently on its face illegal order. Then you get to the issue of command responsibility. If a commander did not order the war crimes, so one scenario is the commander is ordering his men to go out and commit war crimes. But the other scenario, which could be possible, is the commander did not give such orders, but instead we will hold the commander responsible if he knew or should have known that war crimes were being committed. So we're looking at the experience of the commander. We're looking at how the daily reports he's receiving from the battle. We're looking at the communications going back and forth. We're looking at how close he is to the battlefield. Command responsibility is a very powerful tool in going after people and holding them accountable. So let's go to Ukraine. We get reports that things are happening in a particular village or town, okay? We want to get as much information, you want to get as much information that anybody will give you, because as some of you know who've done criminal cases in court, I was a federal prosecutor here in America. We oftentimes get little bits of pieces of the puzzle from a lot of different people, and then we put the puzzle together. So you want to interview people and find out what happened in that town. What did they see? Were there soldiers that had particular insignia on their uniform? Were there vehicles that had particular insignia on their vehicles? Because sooner or later, we're going to figure out what unit that was. And sooner or later, we're going to figure out who the commander of that unit was. So in looking at these horrific war crimes that have occurred, I think that it is unlikely that we will catch many privates who have committed war crimes. Because when they're done, they're going to go back home to their farm in Siberia, and they're never going to leave their farm again. But the colonels and the lieutenant colonels and the generals, that command leadership, well, they're going to go back home to Russia. And in 5 or 10 years, they're going to want to take their family on holiday to Croatia. And I want their name to be on a list when they cross a border. So the idea of holding people accountable is going to take years, because we will not be able to catch everyone on the battlefield. And then we'll be able to follow them when they try to live their lives after that. So that's why all of this is so important. Okay, let me read this here. Given that we have one action by a state that violates several provisions of international law, how does a lawyer prioritize which breach to emphasize before the court, say, for example, before the ICJ? That's a great question. So it depends on the forum, right? So the ICJ, the International Court of Justice, is only state versus state. In the Genocide Convention, very specifically, uses the ICJ as a place that you would go to raise an issue of genocide. So if the ICJ would be for the state. For individual accountability, you'd look at possibly the International Criminal Court, or possibly some other ad hoc tribunal that gets established. We look at domestic laws in Ukraine. Will there be domestic prosecution? One of the things that PLPG has done in working with our partners in Ukraine is we wrote a draft statute for a high war crimes tribunal. So it follows domestic law, but it's a specialized tribunal. See, when we start talking about prosecuting these things in a domestic setting, you have to understand that most of your judges, most of your prosecutors, most of your defense counsel don't have experience with this. So oftentimes, and it is our position at PLPG, it's better to set up a special tribunal, because then you can highly train those judges, those prosecutors, and don't forget the defense counsel. We're democracies. We believe in the rule of law. Unlike Russia, we believe in the rule of law. And so there has to be a quality of arms when we actually do these trials. There has to be qualified prosecutors, qualified defense counsel before qualified judges. So the idea of setting up a national high crimes, war crimes tribunal is something that we think is a good option for you. Ultimately, at the end of the day, the Ukrainians have to decide what you want to do, what forms you want to pursue. As international lawyers who specialize in this, our goal is to just make sure that we give you the menu of options so that you can see what we're looking at and use some of our experience. Okay, we're moving into holding people accountable and going to court. Let's roll back a little bit and talk about war crimes themselves and talk about the law of armed conflict. All right, here's what we don't do. When I train a bunch of young Marines, I do not hand out the Geneva Conventions and say, okay, everyone, turn to page 1. Let's start reading Article 1. We don't do that. We operate on 4 fundamental principles. And if you understand these 4 fundamental principles, you will understand the law of armed conflict. And these fundamental principles will then allow you to open up the Geneva Conventions and turn to Article 35 on the Second Geneva Convention and understand what we talk about with hospital ships. But the reality of it is that we don't necessarily need everyone to have the Geneva Conventions memorized. We need to understand the principles, and that will lead us to fighting it right and following the law of armed conflict. So what are they? First is military necessity. Second is distinction. Third is proportionality. And fourth is humanity. Now, sometimes you'll see humanity written as unnecessary suffering. Sometimes you'll see it written as honorable conduct. I think, and my colleague Lori Blank and I wrote the seminal textbook here in America that is used in law schools and military academies. And I can provide the information to Roman, and he can provide that to you. But the point is that we take humanity and we encapsulate unnecessary suffering and honorable conduct into humanity because we think that's the proper place for it. Okay, so let's start at the beginning. Military necessity. What does military necessity mean? And I'm going to read you the exact quote on what it means. The principle which justifies those measures not forbidden by the law, which are indispensable for securing the complete submission of the enemy as soon as possible. What's fascinating about the law of armed conflict is it is not simply a list of things you cannot do. It is a way to do things. See, we had to write this body of law so that the field commanders could actually accomplish the mission. If you wrote a body of law that was simply a list of things you can't do, and the field commanders get ordered to take that town, and they say, but with this list, we can't possibly take that town. Then they'll crumple up the list, throw it out, and roll away and do bad things to good people. Again, we're trying to protect those who cannot protect themselves. So the concept of military necessity is this idea that you can fight and win, but you cannot violate international law in doing it. And military necessity will not be a defense at your trial later when you try to say, well, I burned down the village out of military necessity. That falls in the same category of I was just following orders. So first and foremost, we understand that armed conflicts are confusing, devastating, destructive places, but we also understand that state A and state B are trying to accomplish the mission. And so we allow the accomplishment of the mission as long as you don't violate international law. And in the situation you're in, you're dealing with an adversary that violates international law on a daily basis. You're dealing with an adversary that has basically decided to ignore virtually all aspects of international law in the invasion, in the way that they've worked inside of that they fought inside of Ukraine. And so military necessity allows us to fight, but you have to follow the rules. Okay, number two, distinction. And there are two parts to distinction. The first part to distinction is that you must distinguish what you're targeting. You must distinguish between civilians and military targets. That's the first rule of targeting, is you must understand what you're shooting at. And the second part of distinction is you must distinguish yourself as a combatant from the civilian population. You cannot hide in the civilian population. I give great kudos to Ukraine. Right from the beginning, you had a lot of people joining the fight, volunteering, coming in and saying, I'm not in the military, but I'm going to fight for my country. And what did Ukraine do immediately, right out of the gate? They immediately wore the armbands, the blue and yellow armbands on their uniforms, on their helmets. Okay, clearly putting them into the fight as a lawful participant, because they're identifying themselves. They are separating themselves out from the civilian population. Okay, so, all right, Olga, if you have an enemy offset in the night, you cannot let some person from that side come to you if they're not demonstrating that they want to become a POW. You don't have time as military to make any mistakes if you're defending your own city and your own state. All right, I'm not sure I understand 100% what you're saying, but Olga, did you want to clarify that? Go ahead.
It was just example for your words that like during war you don't as commander, for example, you don't take with you, I don't know, Geneva Convention or some manual for 100 pages which will tell you what not to do. If you concretely have fire from opposite side and you will not let anybody to come to you and explain, maybe they're civilians with some right by Geneva Convention, you just will not let them come because you don't have any resources to do that, because it's war. It's not, you know, defending or sitting in seminar.
No, I understand. I understand, but I will say this: it is the military's responsibility to understand if there are civilians there. So the military, all militaries, you cannot simply, if you're drawing fire from a particular location, you cannot simply drop 500-pound bombs and wipe out the whole town. You have to make sure that that you're distinguishing what you're shooting at. Now, and I'm not sure if this is your question, but if someone comes to you day or night and puts their hands up and says, I quit, I'm out, then the law requires us to protect them. We cannot kill people who are surrendering. We cannot torture people who are surrendered. And again, we've seen Ukrainian forces do this really well, and we haven't seen the same on the Russian side, where they have killed prisoners of war, and all of those are war crimes. And so, yes, war, again, like to your point, Olga, it's a confusing, messy place. But at the end of the day, if we were having a trial for someone, the standard would be what a reasonable person would do in that situation. So when we hold trials, and we have Americans that have committed war crimes, and when we hold trials on war crimes, we hold them in the conflict zone, because we want other military men and women who are experiencing what they're experiencing so they better understand it. Not some guy who's never left a desk in Washington, D.C. deciding it. We want people who can say, that was not reasonable. I've been there. That was not reasonable. And so have a fair trial that way. Another, Subhash, I don't know if I'm saying your name right, Subhash, regarding humanitarian corridors and the absence of clear agreement, can a state unilaterally declare a particular passage as a humanitarian corridor? I'm referring to a situation like Mariupol, where there are no concrete agreements in humanitarian corridors. Okay, that's a great question. And the fact of the matter is that although humanitarian corridors are something that we want the sides to agree upon, and that we want the sides to say, okay, this road from this time in the morning to this time in the afternoon, we're going to move people. Okay, that's fantastic. But the reality of it is that if those are civilians on that road, and those civilians are walking out or getting water and fetching food or whatever, they cannot be targeted. Civilians can never be targeted. Now, civilians will die, and sometimes it's lawful. And I'll get to that in a moment when we get to our third one, which is proportionality. But do not confuse what I'm about to say with proportionality with targeting civilians. You can never target civilians. That is absolutely 100% a war crime. I'll get to proportionality in a minute. Somebody wrote that we cannot torture in any circumstances. You're right. Torture is illegal under the Geneva Conventions, under the law of armed conflict. It's illegal under the Convention Against Torture. It's immoral. It's unethical. So if you don't like the law, what do you have for morals and ethics? And let me throw this last piece in. It doesn't work. So even if you want to disobey the law and you're an immoral person and unethical, torture does not work. And at best, if someone was applying mental or physical pressure on you to get information, at best, they might get a little bit of correct information out of you. The reality of it is, if somebody is torturing you to get information, you as in human beings, human nature, you are going to tell them whatever it is you think will make them stop hurting you. And that's not valid information. That's why torture is not allowed in criminal trials, because you can get people to confess to things, but that doesn't mean they actually committed the murder. And so we don't allow torture for under the law, under morals, but really pragmatically, it just doesn't work. And then lastly, to your point about not bringing victory on the battlefield, look, all you're doing is hardening the enemy. If you don't follow the rules, and the other side hears that you're torturing people, the other side hears that you're killing people who have raised their hands and tried to surrender, all you're doing is hardening their resolve to fight to the end. And as a military officer, I'm trying to finish this conflict as fast as I can with the fewest amount of casualties to my men. And if I've hardened the resolve of the opponent, then more of my men are going to die. And I don't want that. Okay, so let's move on to number 3, proportionality. Proportionality has a very specific meaning that we use in the law, and I'll read it to you. And there are some key words here. An attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof. So an attack that's expected to cause some civilian damage, whether in lives or property, which would be excessive in relation to the concrete and direct military advantage anticipated. So proportionality is this analysis of what will be the expected civilian casualties, and will that amount be excessive in relation to the concrete and direct military advantage anticipated. So what does that mean? That means that we need to understand what we're targeting. Let's say we're targeting a 5-story building, because on the 4th and 5th floor, there are military on the 4th and 5th floor. But on the 3rd floor is an insurance business. And the 2nd floor is a florist. And the 1st floor is a daycare, a creche, where kids go and stay during the day. You can't just simply drop a 500-pound bomb on that building because there's a few military in the 4th and 5th floor. I need more information. What is the direct and concrete military advantage to be gained? Are those a handful of privates and corporals who are just getting out of the rain and taking a nap? Now, don't get me wrong. They shouldn't be in there. If there are civilians in the building, they shouldn't be in there. But that doesn't mean we're going to drop the building. Or on that 4th and 5th floor, or is it the command and control of the entire battlefield? Is it the battlefield commander issuing orders directing the attack? Now that's a completely different military target. That's a much more valuable military target that will provide a direct and concrete military advantage. Okay, so we need to have good intelligence, good information as to who is where. And the reality of it is we then need to do our best to try to get those civilians out of there before we stage any type of attack. And some of the ways we do that, frankly, will just be by time of day. Those are 3 businesses I listed. At 5 o'clock, they're all going to go home. So we can drop a bomb on the building at 6 o'clock. But what's going to happen at 6 o'clock? The night watchman or the night janitor is going to come in. And that poor night janitor, who's an innocent civilian, is going to die in that explosion. So we take an analysis of what will be the civilian losses compared to the military advantage gained. And in the first analysis, a daycare center and 2 businesses, that's unacceptable. But in the second analysis, this poor civilian night watchman, night janitor, he's going to die. And that will be a lawful targeting because it's not excessive in relation to the direct and concrete military advantage gain. So we can apply that to anything that we're looking at with respect to any type of targeting, any missile that has landed anywhere. We need to do a factual analysis. What did it hit? What was there when it hit? So if a missile lands on a playground, that's bad. But if through our factual analysis, there was an artillery piece launching artillery shells put next to the playground, then that means the playground is going to become part of that targeting. Okay. So military objects cannot be placed next to playgrounds, next to civilian objects, and try to use that civilian object essentially as a human shield. All right, I have 2 hands up. Let's go Olga, and then we'll go to Subhash.
Olga, we can't hear you. Please unmute yourself. Yeah.
Yes, thank you. Actually, I'm waiting for the moment when we will discuss what to do with, for example, terrorist state as Russia, who is not following any international treaties and bodies and laws. And as Mr. Noone mentioned, that it will be good if Ukrainians will do it on national level. But as far as Netherlands already agree, if you know about the special tribunal, so maybe it will be good if we, together with our partners, there are plenty of countries who already say this, will initiate such special tribunal in Europe. But now I want to, because I was triggered, because, you know, for 17 years, I named myself before as child of Amnesty International. That's really great activist organization, which I was together with sisters and brothers, let's say, human rights activists from Ukraine mostly, and from all over the world. We were like children of these values of international solidarity, but after, you know, which lack of good communication skills in which press release, recently I quit publicly with anything of this, because and now you triggered me, and that's why I know there is war time now because of Russian aggression in Ukraine, and I'm actually in Kiev, staying after alarm in the center of downtown. But anyway, I will give you such example. For 8 years, I was monitor on human rights in different international and national projects in Donetsk region. And for example, I will come again to the hotel with colleagues, fellows, journalists, or I don't know, any other friends, or for example, I am local, still staying, even government invite me a lot of times due to my human rights. If you want, you can be evacuated, but I refused. And I am staying, for example, in Pokrovsk, in Bakhmut, in Sloviansk now, maybe in again deoccupied Sloviansk, I am again staying there. And for example, my ex-husband came, who is military, in the same level of the same building with, as it can happen, as actually it was sometimes in Kiev, with other fellows, females and males, Ukrainian military, just for, I don't know, to wash scenes, to do something, to stay. And then you will see military are staying in the same building with civilians.
Yeah.
Then if somebody will attack us, then who will blame? Somebody will sit again
that's
in
a
foreign country and blame my ex-husband or brother or mother or father for being guest at his home, actually, at his home.
So that's a great question. There's a lot there to unpack, but let me try to stay right on the line here with and keeping it with what we're talking about, and that is civilians and military being in the same place. That's the issue, right? And the fact of the matter is that when you are a combatant, which means that you're a lawful fighter in the fight, you are targetable 24 hours a day, 7 days a week, on leave, at home, you're targetable because you're a combatant. And so this makes it problematic if combatants are going to the front line and then coming home and sleeping in their house. It makes it problematic. We need to move those civilians, or we need to make sure the military is over somewhere away from the civilians. You cannot use civilians as a human shield, either innocently, voluntarily, involuntarily. So the fact of the matter is, you're fighting for your life, and I get that. But we're allowing the other side that has dirty hands and has fought a brutal campaign, you're allowing the other side to target something because they can say, well, our intel said we had a whole bunch of civilians, we had a whole bunch of military in there. So Stanley raised a question in the chat, and Subhash, you've been patient, I'll get you in a moment. Stanley said, regarding the issue of civilians, what happens if we don't know civilians are in there? The definition is what we know at the time. So it's what the ground commander knows at the time. So that's going to be the issue. I can very briefly tell you there was a military target in the first Gulf War in 1991 that we hit in Iraq. It was a military facility guarded by a fence, guarded by military men, military going in and out, military facility. We targeted it. What we didn't know, what we didn't see, what was a failure in intelligence is that at night, 250 civilians had gone in there and used it as a bomb shelter. And 250 civilians died because nobody knew they were in there. So Stanley, to your point, we do the best we can with the information we have on the ground. And it's not always going to be correct or 100% accurate. And as a result, people are going to die. Next week, I'm on Capitol Hill, where I've been training staffers for more than a decade, senator staffers, congressman staffers, and I explain all of this to them. So when their senators vote to send U.S. troops into war somewhere, they need to know that civilians will die, and that's a harsh, brutal reality of this area. So we do the best we can. But if we're moving military in and out of civilians, you're causing a problem, and you're allowing the other side to target you. Okay, Subhash, you've been very patient. Go ahead.
Okay. Am I audible?
Yes.
Right. Thank you. So my question, Doctor, is a follow-up from your point, particularly the hypothetical situation and the attack on the building. My question is, what is the standard of precaution that must be taken? Is the law clear on that? So for example, you cannot be relying on a very old drone footage and then launch an attack on a building. So is there a standard in international law? Thank you.
Yeah, it is. That's a great question. And precautions in attack to spare civilians and civilian objects are well enshrined in the law. So we must take all precautions not to harm or kill civilians, not to harm or destroy civilian buildings. But we know that there is going to be military in the 4th and 5th floor of this particular building. So we need to figure out how we're going to do it. Can we do it? Can we take them out by special forces? Can we take them out by some other means that doesn't destroy the whole building? Do we wait them out? And because our intelligence tells us they leave every morning at 7 a.m. to go to the battlefield, and they're just sleeping there at night, and we can ambush them at 7 a.m. And again, I don't want to sound like I'm like Vin Diesel or Rambo or whatever, but the reality of it is that our job is to make the enemy submit as soon as possible. And as General Patton, U.S. General in World War II, famously said, your job is not to die for your country. Your job is make the other son of a bitch die for his. And so we need to understand what the analysis is. And this is the value of drones, because we can keep a drone up and we can establish patterns of life, and we can figure out where people are going and what they're doing. And then we can target them much better. So that's one real value there. So Subhash, excellent question. I want to go to Vladimir. You had a great question about the occupied regions. They don't get to keep it. Under the 4th Geneva Convention, the law of occupation, they're not allowed to change the laws and the structure of the government in that region. So when you see them taking out the government and installing a new government and doing all that, they're not allowed to do that. The law of occupation is quite clear that the people in the occupied regions are supposed to be protected, taken care of, food, shelter, health, education, judicial system, all of that. You may have heard the quote by Colin Powell when President Bush was talking about invading Iraq. And Colin Powell said, you break it, you own it. And what he was doing was summing up the law of occupation. Anything you do in that region, and this law of occupation is hard fought, right? I mean, this is what the Nazis did in the Warsaw Ghetto. This is what the Japanese did in Nanking. So you cannot go in there and just say all of it is now Russia and that's it, and we're changing all the laws and all of that. That's again a violation of international law and the law of occupation. Okay. All right. So let's do the 4th one here. And the 4th one So we have military necessity, distinction, proportionality, and the fourth one is humanity. In humanity, like I said, often talks about unnecessary suffering. So it talks about the way that you wage warfare and the type of weapons that you wage warfare with. So the way that you wage warfare, which would be illegal, would be torture, would be sexual violence. All of that would be illegal under the fundamental principle of humanity. You cannot torture people. You cannot commit sexual violence against people. Also, the types of weapons. You know, the use of cluster munitions, the use of delayed fuse bombs, the use of landmines. These are indiscriminate killers. You cannot indiscriminately bomb a civilian apartment building. Most of the artillery and the bombings that the Russians have done has been very undisciplined, and it's brutal and awful. But think of it from a military perspective for a minute. What are you doing? What are you wasting all those rockets and shells on? You're not actually weakening the Ukrainian military. You're simply proving yourself to be a war criminal by indiscriminately shelling buildings and places that should not be shelled. So when you roll through distinction, proportionality, and humanity, most of what they're doing violates the law of armed conflict, because you cannot simply launch shells into a city with no regard as to who's there and where they are. It's absolutely forbidden under international law. So where does that get all of this, right? When we talk about this, the fact of the matter is, I said this to you about halfway through, this can be very unsatisfying. Well, what can we do about it? Well, unfortunately, we've got to go win a war, and then we can do something about it. But in the meantime, it's organizations like yourself that can investigate and take statements and gather evidence, gather social media from Russian soldiers, gather video, gather everything. Because at the end of the day, we're going to take everything you gather, and then you know that there's some other countries that are using their intelligence assets, tracking who's where, and we're going to figure out who did what when, and then we're going to try to hold them accountable. And even then, it's going to take years to hold them accountable. I mean, the International Criminal Tribunal for Rwanda, the International Criminal Tribunal for the former Yugoslavia, went on for years, and are now in a residual mode where we're still wrapping up some of the cases. In those cases, in each of those courts, they only did about 100 or so trials. So we understand that this is a long fight. And so the fact of the matter is that we need to gather this information. We need to win a war, and then take the accountability where we can. I hate to be a bummer, but I don't think Vladimir Putin's ever going to be in a courtroom anywhere. Okay, I don't think that's ever going to happen. But that field grade officer, that lieutenant colonel, that colonel, that general, he does want to go on holiday. And the fact of the matter is they're closer to the fight. And the fact of the matter is they can control their soldiers. The way the Russian military is fixed, if you have a commander telling their soldiers not to do something, they will not do it because they fear the repercussions that their officer corps would levy on them. So the fact that we see soldiers doing things out there, we know that their commanders are giving them the green light, are approving it. Okay, we know that's happening. Okay, is there a difference between a threat and the use of force? Vladimir, maybe you could give me a little bit of context with respect to what you're thinking.
Okay, maybe he have a problem with
okay.
audio.
Okay, so okay. I don't know exactly what you're asking, Vladimir, but yes, facts matter. So somebody threatening, using force is obviously bad, but somebody using force is worse. Both of them are encapsulated in this concept of aggression, because under the crime of aggression, you're not supposed to be able to threaten your neighbors as either. But certainly once you step over the line and you actually use force, well then it's a much easier case to prove aggression there.
Maybe,
right.
Can I elaborate? Remember, before Russian invasion on 24th of February, Russia have joint military things done in Belgium and in Belarus and in Russia. So common military training near Ukrainian border, it is can be considered as a threat of force. They like showing that they have weapons, that they are mobilizing like 100, 200 soldiers. But with the use of force, maybe we can remember Pearl Harbor incident when the bomb is hitting the American military base, or whether when Japanese military aircraft loaded with explosion materials and the pilot receiving order to fly in bomb. So
right.
Where is the threshold, the red line?
Well, so the threshold here is already surpassed, right? I mean, once they came across the Ukrainian border, then it's met. Going kind of shifting gears to the actual armed conflict, it's going to be about targeting, and it's going to be about who they're dropping bombs on. And so I know one of the questions people were asked about UAVs, unmanned aerial vehicles, and in these kamikaze drones. It's the same analysis. A kamikaze drone is the same analysis as an artillery shell or a mortar round or a rocket or a bomb from a plane. It's the same analysis. What is it hitting? What is it targeting? So it's not, there's nothing illegal about a UAV. Tell me what the UAV is doing. Tell me what the UAV is targeting. And then that's the analysis of whether or not it's been used illegally. Okay. Alexandra.
Yes. Alexandra, you can speak up.
Yes, thank you. Yes, thank you. I'd like to, by the way, I was watching your online broadcast on Facebook, but it was interrupted. You might want to check this one. I wanted to pick up on something that you said earlier about the tribunal and the difference between all these crimes and the chain of command. The crime of aggression is different from other crimes, war crimes and crimes against humanity, because in that case, you don't really need to collect all this evidence, as it was in the case with other tribunals that have taken place before. So it is assumed that the tribunal on the crime of aggression in particular will actually take less time and less effort because it's easier to prove. And the other thing, and that's exactly what my question is going to be to you about, it might be extremely difficult to build a link between a very particular war crime committed, like let's say the attack on the drama theater in Mariupol, and Putin or Lavrov or political and military leadership of Russia in the case. While in the case of the crime of aggression, it actually is built, the entire case is built on preparing the indictment for specifically the political and military leadership of Russia in this case. Would you agree that it might be extremely difficult for ICC, which is currently investigating the crimes committed, war crimes, crimes against humanity committed by the Russian army in Ukraine, to build this evidence up all the way up to the political and military leadership of Russia?
I agree. And everything you said, I think, is spot on. I think the facts of the aggression are self-evident and are going to be easy to prove. We know who ordered it. The issue with aggression is going to be what tribunal can have the proper jurisdiction. That's going to be the issue. Do we need to set up a European Union tribunal? Do we need to, what needs to be done? That to me is the issue with aggression. The other items that you talked about, crimes against humanity. Well, let's say war crimes first. War crimes, probably incredibly unlikely that you could reach back to Lavrov or Putin. Okay, at best you're going to be able to get to the highest ranking general at best, and you probably won't even get there. You'll probably only get to the battalion commander. Crimes against humanity might be a little bit different, because crimes against humanity are so widespread and so systematic that we may, with proper investigation and witnesses and orders that are being sent, we may actually find something there that says, and another way we want you to punish the Ukrainian people is by raping all the women. And if we find a memo or an order that says something like that, and then we know what they're doing out there, then I think we might be able to go higher up the chain on crimes against humanity. So war crimes are definitely down here, and then moving up the chain, moving up our hierarchical pyramid: war crimes, crimes against humanity, genocide. That's a great question. Olga, I'll go back to you, but you have to ask a question. No long stories. You have to ask a question. Go ahead.
Okay, there is a question here. I'm sorry, you are not my commander. Okay, Mr. Noone, thank you. I also agree, and I really like the previous question of Alexandra Drika. I think it's the right time to raise such questions. Mr. Noone, what I'm thinking about, if such international special tribunal will be established in Europe with goodwill of all Ukrainians together with Ukrainian leadership, and with support of states partners in Europe and some others, for example, Canada, if Washington-based international humanitarian law lawyers will see such solution to go into parallel as for top political Russian and military leadership who are guilty for the act of aggression against Ukraine, as for war criminals, International Criminal Court is working about it, maybe some other courts with special jurisdiction can work on these cases. How you see if it will be anyway, because some solution need to be done. This is the question.
No, and that is the question, Olga. That is the question, and that is the question for Ukraine, because I'll tell you a brief personal experience. One of my professors in law school was a prosecutor at Nuremberg, and then after the genocide in Rwanda, I was going to Rwanda to train the 39 surviving prosecutors in Rwanda to prosecute the domestic trials. And I called him up because I said, you were the last person to prosecute a genocide. What tips do you have? And the thing that has always stuck with me, he told me a lot of great advice, but the thing that always stuck with me is he said, justice needs to be done, and it needs to be seen to be done. And it needs to be seen to be done. So it's one thing to do justice, but the people of Ukraine need to see it being done. And so, for instance, the International Criminal Tribunal for Rwanda was actually in Tanzania. So no Rwandans went to the courthouse and saw what was being done on their behalf. And I was in Rwanda when the first genocide conviction came down. And I turned to my colleagues and I said, what do you think? And they said, it might as well be on the moon, because they couldn't see it being done. So the Ukrainian people need to decide, and of course, the Ukrainian people represented by their government need to decide which avenue they want to pursue, because that avenue needs to be one that the Ukrainian people support and are for. I landed in Serbia 2 days after Milosevic had been flown to The Hague. And I was working with a bunch of people who were instrumental in overthrowing Milosevic. And they were all very upset that he was standing trial in The Hague and not standing trial in Belgrade. And so we need to figure that out. Now, there are some legal issues here. If legally the crime of aggression cannot be prosecuted in Ukraine, then yes, then Europe is the logical conclusion. If it can be, then it needs to be a conversation. But war crimes, that's why we did the draft statute to establish a high tribunal in Ukraine, because I think that's the best way forward so that Ukrainians can see it being done. Subhash, you've been very patient as always. I think you're the most patient man here. Go ahead.
Thank you. So Doctor, my question is with regard to your point on proportionality. In a courtroom setting, my question is, who has the burden of proving that either proper precautions were not taken, for example? I ask this because I think it's quite burdensome to ask the party alleging a breach in the principle of proportionality to establish there's been a breach, simply because they would not be privy to the internal calculations that took place. So as a matter of legal point, who has the burden of establishing that there has been a breach of proportionality, for example? Thank you.
That's a great question, and the reality of it is that it's going to be up to us to develop the facts as prosecutors and to present the facts to the court and establish. Let's go back to my 5-story building, right? Establish that everybody knew there were businesses in those buildings. Everybody knew that those businesses operated, 9 to 5. There was no reason to bomb that building at 12 noon when we could have done it at 6 p.m. or we could have done it at 3 a.m. So all those facts will matter. Then the defense will argue about the precautions that they took. The defense will argue about the information that they had available to themselves at that time. Okay, and the defense will argue, because remember, the first line is the expected civilian casualties. So I didn't expect civilian casualties to be there because the information I had was nobody was there. So that's going to be the first line of their defense. The next line is in excess. Well, it wasn't excessive. 10 people died, but look, I got a major general and his entire cadre of staff. Okay, and then lastly, what's the direct and concrete military advantage anticipated? It doesn't necessarily mean that the direct and concrete military advantage that we can visually and touch and feel. It's what we anticipate will happen. Well, if we wipe out the general and his staff, we anticipated these things. Didn't work out that way, but that's how we anticipated it. So it's going to be a very long process going through what the facts are, who knew what when, and then what the analysis was. And prosecutors going to put down their cards on the table, and the defense is going to put down their cards on the table, and then it'll be up to the judge. But that's a great question.
Thank you. We received several questions during the registration for the event, and some of them were double, twice, or 3 times. So I would like to answer all your questions, but let's concentrate at the end of the event with this one. And for example, the first one was, how do IHL regulate the practice of conscription prisoners? Is it the common practice or it's something out of space?
Yeah, that's a great question. And the reality of it is that IHL does not regulate it. So IHL does not, as long as they're over a certain age, so they're not conscripting child soldiers, then IHL does not regulate it. That's a human rights issue in Russia of whether or not they're forcing people to join the military who don't want to join the military and trading, years off a prison sentence or whatever. So that's a human rights issue. It is not an IHL issue. The second question was asked about whether or not we could use Russian POWs for the reconstruction of the country and how is POW labor regulated. This actually ties to the first question, in that if anyone's a POW, when the conflict is over, all POWs must be repatriated. So when it ends, they've got to go back. So this idea that we could somehow use Russian POWs as reconstruction, if we're talking about post-war reconstruction, If we're looking to use POWs during the armed conflict, when we're still properly holding them, there are very specific rules. Number one, you have to pay them. Okay, it cannot be slave labor. You actually have to pay them. Number two, it cannot be anything that helps the war effort. And number three, it cannot be dangerous work unless they volunteer for it. So it's, again, look at what the Nazis did, look at what the Japanese did to the POWs. Those are the rules we wrote in 1949. So it's you have to be very careful about what you do with POWs. I would argue, unless facts change, unless we're talking about, 150,000 POWs, I would argue that this is an area that if I was advising Ukraine, to stay out of. I would not use POWs in any way, shape, or form, because you'll spend more time trying to educate the world how you paid them and you did this and you did that and I followed the rules. And when the reality of it is that there'd already be a TikTok out there demonstrating that you're using them as slave labor, and then you'd lose the public relations campaign. So I think it would be more detrimental than good, and so I would stay out of that practice altogether.
And Dr. Noone, maybe elaborate a little bit more. For example, when Russian POW give interview to Ukrainian media or calling his family back in Russia, this practice is illegal or not advisable, according. Yeah. So
you can't use POWs for propaganda. You can't use them for any public displays. So POWs, see, this is a double-edged sword. Under the law, POWs should not be doing media interviews, okay? They should not be put on TV. However, there's a family back home in Russia that is very happy to see their son is alive and he's healthy. And that meets the needs of one mother and father, okay? But you're not supposed to be using them for public displays. That's the ICRC and the international community is probably going to tell you to stop, because POWs are supposed to be in a protected location, given food, medical, everything, and then at the end be sent home. And I can tell you how important it is, and I know you're treating them well, but I can tell you how important it is to treat POWs well. I was in Germany in 1989, and I met this old man. And this old man said, "You're from America." He said, "I spent the best 3 years of my life in America." He was a prisoner of war in World War II. He said, "We had clean sheets, we had hot food, we had hot showers." And his view of us after the war had always been quite high. And so when you send these prisoners of war home after this war, or if you do them in an exchange, how you treat them is how they're going to view your country. And if we want a long, durable peace, then how we fight and how we treat those who cannot protect themselves, that will speak volumes into that durable peace.
And while speaking about POWs, we also have a question about the work of ICRC, international organization that are bound by its statute to take and protect POWs. And the question is, can we actually accuse the ICRC of inaction and violating its mandate in Ukraine? Maybe in the case of Olenivka, or when the ICRC officials cannot visit Ukrainian soldiers, for example, Azov regiment, to provide them help, to even bring letters of their families to them or from them to Ukraine. How it work?
Yeah, so the ICRC has a very special position in the field of armed conflict. Their position is to act as a protecting party. So there's the detaining power, and then there's the people who are being detained. And the ICRC, as part of their function, is to go and visit and see how they're doing. And then, like you say, bring letters home, but really to see how they're doing. And they're going to visit the Russians and they're going to visit the Ukrainians. They're going to visit both sides. And the ICRC undertakes, and I know this sounds it sounds like something we shouldn't be doing, but it'll make sense, I think. The ICRC basically keeps classified their conversations with the Ukrainian government and their conversations with the Russian government, because the ICRC has discovered and believes that their ability to speak truth to power in a private way will do more to correct their activities and correct them than just running home and doing a front page story on the New York Times. See, the front page story on the New York Times, that's the last arrow in the quiver for the ICRC, because the ICRC doesn't, they don't have an army, they don't have sanctioned power, they don't have any of that. So the last arrow in the quiver, the last resort for them is to publicize that this awful thing's being happened. We've told them several times, they have not corrected it. And that public shaming is the last thing. So they can't go to the public shaming first. It has to be the last. And so it's very unsatisfying. What is the ICRC doing? How come they haven't done this? How come they haven't done that? I would bet money that the ICRC is raising every issue that you can possibly think of with respect to treatment of prisoners of war, with respect to treatment of civilians in occupied areas, with respect to treatment of wounded and sick combatants. They just don't put it on the front page of the papers, right? Alexandra, do you want to jump in on that?
Yes, I actually have a number of questions. I'll start with the first one. Once I spoke to ICRC because we were trying to get as much cooperation with them as possible for them to collect information or get access to the civilian hostages and POWs being kept on the occupied territories. And what I learned from them is that they don't always have access even to all the places of detention. And even though, and they have a problem getting access to those places. And it seems that there is nothing that can be done, let alone the fact that unlike the POWs, the civilian hostages, as we call them, those civilians that are being illegally kept, are not even supposed to be kept anywhere detained by Russia, because they are protected by the who and what can do in this situation to at least try to make the conditions of the civilian hostages in particular and POWs as well better. And my second question, if you don't mind, I will ask straight away. It's
Sure.
Slightly different from this topic. When we had this issue with the press release from the Amnesty International, there was an argument put forward that they confused the international law on human rights with the international humanitarian law, as these are two different concepts, and the international humanitarian law is the one that prevails, and everybody analyzing any ongoing the army through the lenses of the international humanitarian law. If you could comment on that a bit, how do we make sure that this is not confused and that we communicate the difference between the two in the right way? Thank you.
Yeah, that's a great, two great questions. So I'll answer the second one first. When the invasion started, people were talking about human rights abuses, and I immediately stopped. This is a law of armed conflict. Those are war crimes. And now to say someone's a human rights violator, that's a pretty big thing. To me, to say someone's a war criminal is even bigger. And so the reality of it is that I have spent the last several months, and PILPG has spent the last several months explaining to people that it is the law of armed conflict that we're looking at. And we're talking about war crimes by Russia, and we're talking about war criminals within the Russian military and within the Russian leadership. So that's something that a lot of people commonly confuse and conflate, and I get that and I understand that. But these are war crimes. These are violations of the law of armed conflict, which applies inside this armed conflict as a lex specialis, and these are war crimes, especially in an international armed conflict. If this was a non-international armed conflict where there's much fewer law, that's when human rights starts being used more. How do we treat detainees in a non-international armed conflict? Well, let's look at how human rights says we should treat detainees. We have a whole convention. We have the third Geneva Convention that tells us how to treat detainees in an international armed conflict. So let's follow that. So that's what I would say about that. And training and conversations and lecture series and things like that all help that. To your first point about the ICRC, you're 100% right. They don't have access to everything. They don't have a magic wand. They don't roll up in a tank and say, let us see these people. So the ICRC is going to be limited. Ultimately, when everything's said and done, we will find out what the Russians did and did not do and what they allowed the ICRC to do. With respect to civilians, the Russians shouldn't be holding any civilians. Civilians should be allowed to freely move, encouraged to freely move and get out of the conflict zone. And the fact of the matter is that we're hearing atrocities of Russians forcing Ukrainians to go to Russia and handing them a Russian passport and removing children. I mean, let's go back to genocide. The easiest hook on a genocide charge is going to be what the Russians are doing to children. So transferring children will be one of the top line charges here. So these filtration camps and all of this, there's a much bigger body of crime that's taking place here. And eventually, our hope, all of our hopes, is that we can catch some of the people who did this. But there is no world police. And unfortunately, the first order of business is going to have to be winning on the battlefield. And then, but we can in parallel collect this information. One of the reasons why Nuremberg was so effective is because we collected all of this paperwork, tons of paperwork from the German military. And that's what was used at Nuremberg, is all of this paperwork. Today, maybe not so much paperwork, but I'll tell you, there's going to be tons of social media posts of people bragging about this or saying that or doing this. So it'll be the 21st century equivalent of tons of Nazi paperwork. It'll be Facebook and all these other things. So, but two great questions, Alexandra. Thank you so much.
Yes. And we're almost at the end of the event. We received a beautiful question and maybe two last one. And the first is, what are the consequences of non-compliance with IHL? Because it's worrying Ukrainian people a lot. We witness mass atrocity crimes, killing of civilians on the TV, and we live with this every day. And some people losing faith into the international legal system, into international criminal justice. What can we say to such people?
Yeah, and I can only say that the law matters, and like I said a moment ago, there's no world police that's going to come in and arrest perpetrators, but we have to do our best. Yeah, I saw that, Olga. You threw the American flag up there. No, we don't do that either, right? So international law. Look, let's go to 30,000 feet. The knock on international law is always going to be enforcement. And enforcement has a full range from shaming people to dropping bombs on people, and all the sanctions in between, and all the various types of sanctions. And that's what we're seeing now, right? We're seeing the international community applying sanctions, some more effectively than others, but the international community also very concerned about not getting into the conflict that escalates the conflict, that makes a guy in Moscow think he can use a nuclear weapon. Which, by the way, we're doing an event on the use of nuclear weapons on November 4th, PLPG is. So I think Roman will pass it to you and you can put it out to all your folks. I think it's something that people will be interested in. So international law, international humanitarian law, can be unsatisfying at times. It doesn't have the best answer, but know that it's there and know that we're that we're collecting this information, and on the back end, and it's going to go on for years. This is not going to be, oh, the war will be over in 4 months and all the bad guys will be in jail in 10 months. This is going to go on for years. We're going to be having this conversation about holding Russian war criminals accountable for 10 plus years. And I know people don't want to hear that, but it's just the truth. We've seen it in every other scenario. I mean, but for a total World War victory, like in Germany and Japan, we've seen it in every other conflict. It takes years. It took the Cambodians 30 years to even start talking about a trial. So now that's a special set of facts, but the point is, it takes a long time. And so what I would say to the Ukrainian people who are maybe losing faith in IHL is I would ask them to keep faith and to keep notes, because we're gonna track these guys down. I know for certain that the Western countries are using their intelligence assets to track each battalion, each brigade, each unit. And then when the media goes in and says, Bucha, look what happened here, we know who was there. And we know who's in that chain of command. And the guys that ordered this and or let it happen will be held accountable at some point. Maybe not that private or that corporal who goes back to the farm in Serbia, but that field grade officer is going to be held accountable. That I'm certain of, unless they want to stay locked away in Russia forever. And at some point, people are going to want to move, and we'll get them.
Professor Noone, thank you for your answer, for sharing your knowledge with us, and for sharing your strong position on these matters. And I will briefly emphasize that today we start like this typical curricular lecture, but our audience was so engaging, and we have real interactive seminar. I received almost 20 questions during this evening. So in the following day, you will receive, everybody register, will receive an email with links to legal materials that we discussed today, with the link to a video, just in case you would like to rewatch some parts and digest all the information that you receive here. And also text in writing, question and answer session. I will make sure that everybody will receive the answer that would like to hear today. And on this note, I'm so grateful to Professor Greg Noone for his expertise. And please stay tuned with our future events in IHL matter, in environmental law, in media freedom matter. We will be here with you in future. Thank you.
Well, thank you, Roman, and thank you, everyone. And it's been my privilege to be with you, such a remarkable group. And I applaud the work that you do, and don't lose faith. Keep doing it, and we're going to get these guys. We may go gray and we may lose our hair like you, Roman, but we're gonna get these guys. Okay. So
thank you.
Enjoy the